Hello, everybody. I'm Janet Dolgin, and it's a pleasure to present this webinar on behalf of the Public Health Program and the Maurice A. Deane School of Law. The webinar will consider the purpose of advanced care planning for medical decisions. It'll review the need for such planning, and it'll summarize the legal background. I'm going to look at a set of Supreme Court cases that brought public attention to the issue, and we'll then focus on the laws of New York State because that's where we are. The laws I'm going to look at concern medical decision-making for patients in need of complex medical decisions, sometimes end-of-life decisions, who themselves do not have the capacity to make their own medical decisions. All of these issues raise many complicated legal and public health questions and challenges. There are really a number of public health populations that are of concern, and even more of concern perhaps is the relationship among these populations. There are patients themselves. There are people who may one day be, but are not yet patients. There are people who are going to be making decisions for patients in need of care, but without capacity, as well as the clinicians, the physicians and nurses who are caring for those patients. And so I think as a general matter, the best responses to these challenges grow out of partnerships among attorneys, public health professionals, and clinicians. Medical decision-making by and for people facing complex medical decisions can often be very frightening. Many people prefer not to think about it, but increasingly I think it's important to be prepared. And that's what I'm going to talk about today, what that means, where the motivation has come from to encourage people to be prepared, and how one can be prepared. In his new book, Being Mortal, Atul Gawande writes, "Scientific advances have turned the processes of aging and dying into medical experiences, matters to be managed by healthcare professionals. And we in the medical world have proved alarmingly unprepared for it." Gawande says a lot there. In the first place, it's interesting to think about the medicalization of a set of processes that happen to everybody all the time, and that in many ways were not in particular defined as medicalized. People on the whole did not die in hospitals until the last century. The focus of Gawande's quote here for our purposes is the notion of being unprepared, and even as the medical world in Gawande's view is unprepared, the public is quite as unprepared. Medical technology can keep people alive for many years, yet it's not clear that more treatment is always the best care. Something like 80% of Americans say they would prefer to die at home. Most people do not die at home. However, generally, those people who talk with others, including family members and friends and clinicians, about their choices should they face the need for complex medical decisions and not have the capacity to make those decisions themselves, those people are more likely to have their pre-incompetency wishes met. Certainly, clinicians can provide more appropriate care for patients if they know something about their pre-incompetency wishes. Family members and sometimes friends who make decisions for patients who no longer enjoy capacity are certainly more likely to know what the patient would have wanted if they've entertained conversations with the patient while the patient was still capable. And moreover, and in truth quite as important, the moral suffering endured by surrogate decision makers has proved to be extreme. This really is a process that raises unending, difficult, emotional, intense challenges. And research about the experience of surrogate decision makers has shown us that although the task is difficult in the very best of circumstances, it's remarkably eased if the surrogate decision maker knows something about what the patient would have wanted. To make a decision and be able to say, I do this because I know this is what a mom or dad or cousin Billy would have wanted, brings great moral relief to a decision maker who is, in truth, making life and death decisions. Interestingly, the movement to encourage people to consider medical choices before they're sick and before they're dying grew out of much broader changes in the social world of medicine in the last half century. In particular, we've seen remarkable shifts in the character of the physician-patient relationship. And for several decades now, the law in the United States has provided that patients not only have the right to consent to or refuse medical care, including care deemed necessary for life, but in addition, those decisions must be predicated on the patient having received adequate information. Patients must be told about their diagnosis or diagnoses, about recommended treatment, about the risks and benefits of that treatment, and about alternatives. These requirements have really seen the collapse, or in some way been the consequence of the collapse of a more ancient presumption that doctors alone should make medical decisions. The shift has been summarized in a pithy manner by the philosopher Gerald Dworkin, who said patients have moved from saying, doctor knows best, let the doctor decide, to today where patients say, it's my body, I should have some role in making these decisions along with my clinicians. This shift raises especially challenging problems for patients without capacity. If the leitmotif of our response to medical decision-making is patients should play a part in entertaining and affecting conclusions about their own medical care, it's hard to know what to say with regard to patients who no longer enjoy capacity to make their own medical decisions. And in the course of the last several decades, the nation has developed a set of social and legal responses that encourage people to articulate their wishes while they're capable and to name, if possible, somebody, typically called a surrogate decision maker, who will actually be available and able to make decisions should the patient need medical decisions and not enjoy capacity. On the one hand, surrogates are understood as sort of standing in for the patient, and in that regard, they preserve the patient's right to autonomous individuality. Obviously, there's a bit of a fiction here, since the surrogate is not the patient, and may or may not know exactly what it is the patient would want, even if they know what it is the patient would have wanted, that is, what the patient said he would have wanted or she would have wanted while still capable. A few court cases decided in the late 20th century and the early 21st century called public attention to these issues. These cases all involved either disputes between family members and healthcare providers and hospitals, or disputes among family members about appropriate care for a loved one. All of the cases that I'm going to refer to now involved disputes about the withdrawal of life-sustaining care. The first important case in the United States was a case decided by New Jersey's highest court. It was decided in 1976, and it involved a 21-year-old woman named Karen Ann Quinlan. Karen came home one night from a party and collapsed. She was anoxic, left without oxygen for 2 15-minute periods. She was resuscitated. She was put on a ventilator and survived, but entered into a persistent vegetative state. When her condition didn't improve, her parents asked that ventilatory support be withdrawn. Today, that sort of request is entertained not infrequently. It was extremely unusual 4 decades ago. That was a very long time ago in the context of decisions about withdrawing life-sustaining care. Interestingly, Karen's father, who was the primary party representing his daughter in this case, was opposed by the hospital, by Karen's doctors, by the local prosecutor, by the state, and by the guardian ad litem for Karen. And interestingly, one of the witnesses who testified in the case said he couldn't imagine any doctor authorizing the withdrawal of life-sustaining care from a patient who was not brain dead. Karen, of course, was not brain dead. She was in a persistent vegetative state, but she was not dead by any definition of the term. Yet, despite this background, New Jersey's highest court concluded that Karen's father was a competent decision maker, a competent guardian to his daughter, and granted him the right to authorize the withdrawal of respiratory care from Karen. The New Jersey court explained that a competent patient had a constitutional right, both under the U.S. and New Jersey constitutions, to refuse care, even life-sustaining care, and found, moreover, that a comparable right was to be enjoyed by a patient no longer capable through a surrogate decision maker. The Quinlan case changed the shape of social responses and legal responses, and a slew of legal changes and challenges followed in the course of the next several decades and continues today. The next case that brought significant public attention to these issues was considered by the United States Supreme Court. It was the case of another young woman named Nancy Cruzan. Nancy, like Karen, was rendered anoxic for a significant period of time, and like Karen, Nancy entered into a persistent vegetative state. In Nancy's case, it was the consequence of an automobile accident in 1983. When it became virtually certain that Nancy would not recover, her parents sought to have life-sustaining care withdrawn. Nancy was in Missouri. The law there required clear and convincing evidence that a patient would have wanted life-sustaining care removed before that could happen. And the Missouri Supreme Court, which considered Karen Ann Quinlan's case, did not find that level of evidence. Nancy's case. Nancy's parents brought the case to the United States Supreme Court, which agreed to hear the case. That court began by reaffirming, even if somewhat hesitantly, the right of a competent adult to agree to or refuse medical care, even life-sustaining care. But the court, unlike the New Jersey court in Quinlan, the Supreme Court in Cruzan did not find a constitutional right for a surrogate decision maker to withdraw life-sustaining care without clear and convincing evidence that that's what the patient would have wanted. Now, it's important to understand that that decision did not mean and does not mean that states cannot rely on a less strict standard than the clear and convincing evidence standard. What Cruzan means is that states do not have to put into place a less strict standard, that Missouri was within constitutional bounds in requiring that the patient's wishes be shown at the level of clear and convincing evidence. And Missouri, like New York for many, many years, took that standard very seriously in these cases. More recently, the Shivo case in Florida again brought social and legal attention to issues that revolve around an effort to withdraw life-sustaining care from a person in a persistent vegetative state. The Shivo case involved another young woman named Terry Shivo, who had been in a persistent vegetative state for many years when her husband asked that life-sustaining care be withdrawn. In this case, it was not the hospital or the physicians, it was Terry's parents who disagreed. The case was remarkable in having been considered by virtually every level and branch of the state and federal legal system. In fact, the Florida governor and the United States president both weighed in, and they were brothers, the brothers Jeb and George W. Bush. Eventually, the original trial court decision in Florida was supported. That court had decided that there was, in fact, adequate evidence to allow Terry's husband to authorize withdrawal of life-sustaining care. In Terry's case, it was not respiratory support that was at issue. It was assisted nutrition and hydration. In 2005, that life support was withdrawn. The case again brought enormous attention to the challenges presented to the nation by and for people without capacity and in need of significant medical decisions, as well as to the challenges faced by their loved ones facing the task of making medical decisions for patients like Quinlan, Cruzan, and Shivo. State legislatures have also responded to the dilemmas occasioned by questions about medical decision-making for patients without capacity. The first state to pass a relevant statute was California. Interestingly, we see California is often a pioneer in matters like this, just as it has been a pioneer in statutes that transformed the family law system. In 1976, California became the first state to provide by statute for surrogate decision makers to make medical decisions for patients lacking capacity and in need of significant medical decision making. Other states followed California, and by the early 1990s, all of the states had some sort of statute in place that provided for advance planning. Now I want to turn to New York. New York was a latecomer in this arena. It was a latecomer both in providing by law for advanced care planning and even more of a latecomer with regard to planning for decision making for people who have not signed advanced directives. Now the state has responded through a number of statutes promulgated over a 2-decade period. In addition to providing for advanced directives, New York now authorizes surrogates to make decisions for people without capacity who did not complete advanced directives. The first important law in New York on this front was passed in 1991, and it's called the Healthcare Proxy Law. It reflected a really significant shift for advanced care planning in New York, but it was less consequential than it might have been because the possibility of signing an advanced directive only carries importance if people actually do prepare these forms and have them executed. In fact, most people, even to date, have not done that. In the country as a whole, there are various estimates, but it seems as if somewhere between a quarter and a third of the nation's adult population is actually completed an advanced directive. The New York law allows people, while capable, to appoint agents. The language here is a little confusing. New York uses different terms in different statutes. In this statute, the law calls the agent a proxy. So New York law now allows people to appoint an agent or a proxy who can make medical decisions for the principal, for the patient, should he or she become unable to do that. I will refer to these proxies by the term agent because the term proxy can be somewhat confusing. It refers both to the person, the agent, who can make medical decisions, and it refers as well to the form that authorizes that person to make such decisions. The agent in New York does not have to sign the proxy form. In fact, the agent doesn't even have to know that the proxy form is being completed, though clearly it is a mistake for a person to fill out a proxy form and name an agent, a proxy, as the law calls that agent, without talking to the agent, without, at the very least, making sure that the agent is willing to serve in that role. And even more than that, it's extremely important for a person naming somebody to make decisions for them to have a significant conversation with that person about their wishes, their values, their needs, and their choices should they face the need for complex medical decisions and not enjoy capacity. Under New York's law, people may ask for limitations on care. They may ask that, quote unquote, everything be done, or they may ask for something in between. A proxy is expected to make decisions that reflect the patient's pre-incompetency wishes. In the best of all circumstances, the agent knows what that wishes are, and those wishes have at least in some form been noted on either the proxy form or a living will document. Living will documents are not expressly provided for in New York law, but they can be filled out. They serve at the least as, quote unquote, clear and convincing evidence about a patient's wishes. Probably their most important use is for a patient who does not want to name an agent, who does not perhaps know who to appoint, but still has really clear wishes about end-of-life care. That person can fill out a living will and describe what he or she would like to have happen. For people who fill out proxy forms, information can be authored on the form or in the living will supplement about what the patient would like to see happen. There's some controversy, actually, about how detailed these instructions should be. On the one hand, it is of significant help to a patient's surrogate decision makers, to the agent, and to the clinicians if they know what it is the patient wanted. On the other hand, very detailed instructions are often hard to interpret and may be difficult to affect in specific situations. More generally, the healthcare proxy law does not help the majority of people in New York because they simply don't complete proxy forms. For many years, this majority was left with a rule laid down, or a set of rules laid down in two cases decided by the New York Court of Appeals, New York's highest court in the 1980s, In Re Stora, and in this context in particular, a case called in Re Westchester County Medical Center, typically called O'Connor, the name of the patient in the case. These cases effectively precluded the withdrawal of life-sustaining care for patients who had not clearly documented what it is that they would have wanted to have had happen, that is to say, that they would have wanted life-sustaining care removed should they ever be in a situation such as the one that they were in fact in. Stora involved a middle-aged man dying of cancer who had the mental capacity of a toddler, And O'Connor rigidly defined the clear and convincing evidence standard for people who had enjoyed decision-making capacity but who had lost that capacity. Together, the cases suggested that it would be in New York extremely difficult to withdraw life-sustaining care, even from people who had once been capable and who had made it clear, but not absolutely clear, that they wouldn't want life-sustaining care continued should they be persistently vegetative or in a number of other situations. It took about 2 decades after passage of the healthcare proxy law for New York to pass a statute responding to the needs of people who have not completed proxy forms. In 2010, the state passed the Family Healthcare Decisions Act. This law provides for selection of a surrogate decision maker who can make decisions for a patient who no longer enjoys capacity and who did not complete an advance directive. For patients in this situation, surrogates are identified according to an order of priority outlined in the statute. First, a court-appointed guardian, then a spouse or a domestic partner. Third, a child, an adult child, a child of 18 or older. In every case, the surrogate decision maker has to be 18 or older. A child, a parent, a sibling, and then finally, and quite interestingly, a close friend. And this law allows appointment of a decision maker for the vast majority of people, not for everyone. Sometimes it is not possible to find a decision maker. For most people, it is possible. However, it doesn't obviate the need to prepare an advance directive because the decision maker appointed pursuant to the Family Healthcare Decisions Act may or may not be the person that the patient, while competent, would have selected. The Family Healthcare Decisions Act directs surrogates to make decisions in line with their knowledge of the patient's wishes, but the standards are somewhat flexible regarding most medical decisions, less flexible regarding the withdrawal of life-sustaining care. And in this regard, a specific set of conditions have to be met before that can be authorized. For example, one situation in which life-sustaining care can be withdrawn occurs, and here I quote from the statute, if the treatment would be an extraordinary burden to the patient, and in addition, an attending physician with the concurrence of a second doctor has said that the patient is likely to die within the following 6 months, or that the patient is permanently unconscious. This law has changed the name of the day in New York, but still the Family Healthcare Decisions Act has to be understood as offering default positions that may or may not satisfy the pre-incompetency values and wishes of particular people. Thus, it remains compelling to think about completing proxy forms in New York, advance directives of various sorts elsewhere, and in doing that, to have serious conversations with whoever it is who will be one's surrogate, as well perhaps as other family members, and quite as importantly, with one's clinicians. Patients should talk to their clinicians about their wishes and their values, and it's as important perhaps that people not wait till they're old and sick for this to happen. This should happen when people are young and healthy. It's not that one should necessarily complete a proxy form at 32 and never change it. Forms should be reconsidered every periodically, or if there's a significant change in one's situation. But Anybody can become seriously ill and need healthcare decisions to be made by others. And in addition, people may be asked to serve as surrogates for elder relatives. So one of the take-home messages, I think, of the highest order is that these decisions shouldn't wait until people really face the need very imminently to have medical decisions made and face the possibility that they won't be capable of making them. Since 1990, federal law has required hospitals and other healthcare facilities to inform patients about advance directives, but that law does not mandate that patients complete such forms or that they select surrogates. Certainly more and more people are aware of the opportunities offered to engage in advanced care planning, but still the minority of adults in the United States have done that. The majority of cases that go to court in the United States about withdrawing life-sustaining care involve, as you would think, people without capacity who have not completed advance directives. And these cases offer a very, very strong argument in favor of considering advanced care planning and doing that long before one is being wheeled into an emergency department in a life-threatening situation. Again, an essential part of this planning goes way beyond the strict requirements of the law and involves conversations, serious conversations, often, of course, very difficult conversations about the issues. Each of these conversations is unique. Each is shaped by the values of the patient and the relationships between the patient and his or her surrogates and clinicians. In conclusion, advance directives can best be understood as an offshoot of the informed consent doctrine, an offshoot that provides for the needs of people no longer able to entertain informed consent conversations. Development of the advanced care planning option was part of an effort to respect patients without medical decision-making capacity by honoring their pre-incapacity wishes. Advanced directives often make the process of dying less difficult in a society that for several centuries has hidden dying from public view. Advanced care planning can ease the very serious moral distress that often burdens surrogate decision makers. It directs clinicians to provide more appropriate care by following the pre-incompetency wishes of their patients, and it bestows dignity on dying people by honoring their wishes for medical care voiced while they were still capable. Thank you so much. We're happy to consider any questions that you may have. Somebody asked about capacity. That's a very good and interesting and important question. How does one know that a patient no longer has capacity to make a medical decision? Not having capacity does not mean that one is in coma or persistently vegetative. People are sometimes deemed not to have capacity who are able to converse, and even more, people are sometimes deemed not to have medical decision-making capacity with regard to a particular medical decision, even though they're deemed to have capacity in a more general context. Broadly, a person who has capacity is able to understand the character of his or her medical situation, is able to understand treatments and diagnostic techniques that are being proposed. Such a person is able to appreciate the consequences of his or her illness, as well as the options for responding to it. Physicians can make capacity determinations. Very often in hospital contexts, the psychiatrist is asked to determine capacity. Certainly that's something within the very specific expertise of psychiatry, but a physician is allowed to make that determination. A second question that's been asked, and this relates to New York's Family Healthcare Decisions Act. What is a domestic partner and what is a close friend? Again, those are very, very good questions. Interestingly, this law was passed just as New York provided for same-gender marriage, but before same-gender marriage was a possibility in New York, the only legal option for same-gender couples was the domestic partnership. There are also domestic partnerships that involve people of different genders. A domestic partner is defined very broadly under the statute. One cannot be a domestic partner if one has a spouse, but if one doesn't have a spouse, a domestic partner can be identified because one is in such a legal relationship anywhere, cemented anywhere in the United States or abroad. But in addition, a person covered under another person's insurance policy, but not a child or a parent and so on, is defined as a domestic partner. A person with whom one lives, a person with whom one has children in common. A close friend is anyone who's 18 or older. It cannot be one of the relatives noted in the statute. A close friend is expected, and here I quote the statute, to have maintained such regular contact with the patient as to be familiar with the patient's activities, health, and religious or moral beliefs. The close friend designation is an interesting one. It really suggests the legislators' interest in making sure somebody could stand in as a surrogate for the patient in situations where there was no domestic partner, or spouse, or child, or parent, or sibling, or so on. In that case, it's possible to look for somebody who says, I was a really close friend of this patient, and I think I know what they would have wanted, and I'm able to make medical decisions for them. So here's a third question. The Terry Schiavo case gained a lot of media attention. What did it make any new law? And interestingly, that case was plastered on the front page of virtually every newspaper in the United States for month after month after month. It made virtually no new law. In the end, Florida law remained as it had always been. The real issue in that case was whether the husband had or had not met the requirements of Florida law that Terry's pre-incompetency wishes were clearly designated at the level of clear and convincing evidence. In the end, the courts decided that had happened, but the case really made no new law. It was important because it brought public attention again to the issue and encouraged people to think about, advanced care planning. Here's another question. What are the means that one has to know whether a close friend or another surrogate is him or herself capable of serving as a surrogate at the time that a decision must be made? That's an important and interesting question. New York law, if one fills out a proxy form, one has the option of not just naming a proxy, an agent, but of naming an alternative. The person one names as one's proxy may not be available, may live 1,000 miles away and not be able to come and participate, may say, I simply can't do this for whatever reason, may not be alive any longer, or may him or herself not be capable. And it is actually possible to make the decision that an agent does not enjoy the capacity to make medical decisions. in New York, another family member of the patient or a hospital ethics committee can bring a case to court if there's a disagreement about the person who is serving as surrogate pursuant to the explicit list offered in the Family Healthcare Decision Act. Somebody asked what happened to Karen Ann Quinlan and Nancy Cruzan. Interesting in both cases. Karen's father, as we saw, was defined as her guardian by the New Jersey court and was given the authority to ask for the withdrawal of respiratory support. That happened. Karen lived for a very significant number of years after that. That sometimes happens. People who are on respiratory support can be weaned, and it turns out they didn't need it. People who are persistently vegetative are not brain dead, and they may well have the capacity to breathe on their own. In the case of Nancy Cruzan, there was an interesting legal story after the Supreme Court case. After the Supreme Court said that Missouri did not have to provide for the parents to gain authorization to withdraw life-sustaining care from their daughter, two of Nancy's friends came to the parents and said, you know, we didn't realize that this Nancy was the Nancy we knew so well. Nancy had been married and had been using a different name when they knew her. And they said, but we had very explicit conversations with her about this very issue. The Missouri courts offered to entertain the case again in light of the statements from these young women, and now the court said there was clear and convincing evidence that Nancy herself would have wanted life-sustaining care withdrawn, and that in fact happened. Thank you so much. If there are questions that we didn't get to, we'll try to answer them by email. We very much appreciate the opportunity to present this webinar.